Hello, welcome to Civic Conversations. I am your host, Marvin King. On today's episode, we have Ron Rychlak, Distinguished Professor of Law, and Jamie L. Whitten, Chair of Law and Government. Professor Rychlak has won numerous awards and accolades in his 30-plus years of teaching, research, and service at the University of Mississippi School of Law. Most pertinent to today's episode is his service as the university's faculty athletic representative. In that role, Professor Rychlak will help us understand the changing nature of college athletics, and in particular, name, image, and likeness, commonly referred to as NIL. Ron, thank you for your time and welcome to the show.
Thanks, Marvin. Delighted to be here.
If you weren't paying attention, the evolution of college athletics from amateurism to this hybrid model seems to have emerged suddenly. My first question is, was this inevitable? This move away from amateurism, I'm not sure if we can call it professionalism just yet, but is it inevitable how we got to where we are?
Sure. Well, that's a very good question. Is it inevitable? Was it inevitable? I don't think it was, but it's been slow and long coming. And I always point out to my students that you can look back at Three Stooges and Marx Brothers. Both have comedy sketches that they did in the 1930s about colleges hiring pro football, or, professional people, paying people to come play football for them. And there's been that drive, and that's really kind of behind all this, is that people want to have their teams do well, and they're willing to spend money to do it, and that puts us in a tight situation.
So that is definitely seems like the American way. We are willing to pay. Sports are, quite frankly, different here than anywhere else. Just the mere fact that we have college athletics, when you look at countries around the world, you don't really see college athletics except for maybe, the crew team at Oxford and Cambridge. So we have a different model here. So let me ask you this. What are the two or three most important developments that have led to NIL, whether it's legal or political, any particular individuals? What two or three stand out to you that have kind of led us to this path?
Well, we can point to a lot of different things, but I mean, Ed O'Banion, the former college basketball player, is playing a video game, an EA game, and he notices himself as one of the characters. Shoots left-handed, wearing his number, same color, same team, all that kind of stuff, and he realizes somebody's making money off of his likeness, his image, his talents. And he said, and I'm not making money off of it. Somebody is. And that kind of started the process rolling. And he ultimately brought a lawsuit. The immediate result of the lawsuit was basically shutting down the game. But it opened eyes. People started thinking about, gee, there are people making literally millions of dollars, individuals making, coaches, big time coaches, making that kind of money, and the players are not making money off of it. They're not able to capitalize off of their own personal rights. And that started the wheel going, if you want to point to the first thing, I believe.
Does the NCAA react to this, or are they like, well, okay, that's just between the athletes and EA, like a third party? Does the NCAA start to make changes at this point, or are they happy to leave well enough alone?
No, the NCAA did not react. The NCAA leadership through this period, I think, did not do well. Did not do well on a number of things. And I think there are moves they could have made that would have left us in a different situation at the time. I thought so at the time. So this isn't all looking in the rearview mirror and figuring out. But they were very committed to the amateur model, the collegiate model, the idea of amateurism and not paying anyone. There were there's a case I remember back when I was in law school that struck me as silly at the time. There was a college quarterback who had been a big time skier, and they wanted to pay him to endorse some skis, and they wouldn't let him do that. And it had nothing to do with football. It was only because of his skiing prowess. And it didn't make sense to me at the time, and didn't make sense to a lot of people. But the NCAA said, you're not making money off of your athletics because you are an amateur. And one of the cases that I think illustrated the hypocrisy of the NCAA at the time was Johnny Manziel, the quarterback at Texas A&M, who got in all kinds of trouble for going to a party, getting paid for a party or something. Manziel went way beyond that later on, but early on he got in trouble for fairly trivial things. But the NCAA was selling jerseys with his name on the back. You could go on the NCAA webpage, and the NCAA was making money off of his name, and they're punishing him for getting paid $50 to show up at a bar opening or something like that. And you look at that and you say, this isn't fair. And people looked at these early situations and just said, what's going on is not right. And by the way, a lot of people were looking in and saying wasn't right, also did not understand the full scope, the full picture. So a lot of the people were upset over legitimate things, but didn't have the complete scope in mind at the time, didn't understand that the money the colleges were bringing in was being spent on non-revenue sports, on women's sports, on other things. So you get an agitated base, you start going to court, you start having success in court, and we're in a situation that where we are today, which is, I think everyone says, not sustainable.
Is this a antitrust? Is this a restraint of trade? Like, from a legal perspective, what would be some of the issues that a court might say, okay, NCAA, here's what you're doing that needs to be fixed?
Well, and that's exactly what's at the heart of that most recent settlement, the House settlement in 2025. The in a competitive market, we want Coca-Cola and Pepsi not to collude on price, but to compete over price and quality, so consumers get better deals, get better products back and forth. Whether it's Ford and Chevrolet, Miller and Budweiser, whatever. You want that kind of competition, and we have laws, the Sherman Act, to make sure that happens. And if people collude, they can fix prices and lessen quality, and so we have laws against that laws against antitrust. And the concept behind many of the actions, certainly the House litigation, was that the NCAA is, in essence, the NCAA. We get mad at you get mad at the NCAA. It's a club. The universities are members of a club that have gotten together, and we hate the NCAA except we're members of it. We could
That's
change
right.
the rules, except most times we're kind of okay with the rules, except when they're coming after us. It's a funny thing, but as a club, we have agreed to set these rules, and the rules say, well, and we need some of that. We need to agree that a football field's 100 yards long, and that it's the 3-point line is here, and we're going to play quarters or halves, and here's how long they're going to be, and you need to have some rules and regulations. So it's not a fully competitive market. You can't have uh, the the Alabama Crimson Tide doesn't exist on its own. It has to play against other teams, which is not
That's right.
really true. Not really true of other products. So it's not a one-to-one comparison. But
Correct.
the argument is that the teams have colluded sort of against the players, the student athletes, and agreed not to pay competitive benefits. And so, in doing that, they are acting in an anti-competitive way, violating the Sherman Act. Um, the House case was settled before that was taken to court, because and one reason was because if they found an antitrust violation, it triples the damages.
Okay.
So, so
The
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 NCAA had an incentive to settle.
NCAA and the originally 5, now 4 big conferences were the named defendants, and they would have had to pay triple damages. They were in the same court that had decided the O'Bannon case and decided another case we haven't mentioned yet, but the Alston case. But the NCAA had been beaten twice in the same court in front of the same judge that the House case is in front of. So,
Tell us about the Austin case, uh, and what that means from a legal perspective first.
well, the Austin case was more or less a related antitrust allegation. And so at the time, before these rules started to fall, if you and I we're athletic directors at major colleges, we're trying to attract the best athletes to come to our college and play for us. Of course, part of it is the academic reputation of the school, the location of the school, the beauty of your school. There are those things that you're sort of outside of your control as an athletic director. As an athletic director, the two things you really could compete over is you can get the best facilities. So we saw this arms race of facilities that for the last 30 years or so, bigger, better, continually developing all kinds of stuff. And you could get the best coaches. The name, which meant if you were a named coach, suddenly you went from being paid, comparable to the top professors to being paid millions and millions of dollars. Because if I get the best coach, I'm going to get the best players come play for that coach.
This explains why I always see these maps of the highest paid state employee of each state. And it's either a football coach 90% of the time or, a basketball coach in a couple of states and maybe the
Right.
occasional orthopedic surgeon, something like that.
It was the only way you could pay legally players to come. We'll give you the best. And so that drove the salary up for the coaches, which, by the way, had this inverse sort of incentive of that people start seeing these coaches making insane amount of money and the players not getting anything. That exasperated the situation. But going back to the Alston case said that the players not getting anything. The result of that was the court held you could not. In this case, made its way to the Supreme Court, and particularly one of the separate opinions. Written and I'm blanking on a name right now, but the Supreme Court made it very clear they were not happy with where the NCAA was, and the the court upheld the ruling from below, which said you could not limit academic qualifications for your athletes. You couldn't. They got full amount of any academic money, which could include books, computers, anything at all that you could not limit that. It
Okay.
was limited. It was only to that far, but what a number of schools did, and I think every SEC school did, they immediately figured, what's the maximum amount that we can pay a player that we can tie to athletics? And it was roughly $6,000 a year, I believe. That's on top of a full scholarship, $6,000 a year, because that could make sure cover and anything. It had to be related to academics, but they basically figured out what's the max. You need a camera for a class. You need this. What's the max? And it was about
Okay.
$6,000. And then it had to be tied to academics. So then we had to say, well, how do we tie it to academics? Most schools decided it meant, well, they had to be eligible. You can't
Okay.
you can't pay that unless you get eligible. Now, this gave the athletic department, a little bit of leverage over the athletes, because now there was something they could take away. Hey, if you don't show up for your tutoring, you're going to get
Okay.
docked, going to get fined. There was a little bit of stuff that came with that,
Okay.
but that was second step after O'Bannon. Now recognize O'Bannon was outside deals. It's selling to an outside entity. This now was from the school, but it was limited to academic expenses. So it had a cap on it, and there was a requirement of academics tied to it.
We're gonna close up here in a minute. We could talk about this all day. In fact, I'm sure you could talk all semester. We could talk
I
all
do.
semester. But that's right. So hopefully listeners hear this and end up going to the Mississippi School of Law and can take your classes. Something that has gone on parallel with this is the even outside of COVID, the extension in the years that students are eligible to compete. We're getting these 6th, 7th, even 8th year cases. And it seems that now the incentives have changed for the student athletes because now they're getting paid. Whereas before, when you were an amateur and you weren't getting paid, after 4 or 5 years, you were ready to go and get a job. But now the incentive structure seems to have changed for student athletes to stay in school longer. Am I reading that right?
Absolutely. I mean, it used to be what you go in baseball, you go play minor leagues, and you're living 6 guys in an apartment, sharing a van. It's a very nice lifestyle for athletes at major colleges, and especially if you're getting paid as primarily uh, football, men's basketball, to a somewhat lesser extent, women's basketball. You're making better money than you'd make playing in the Canadian Football League or basketball in Europe, which used to be options for people. So if I can get an extra year, 2 years, staying in college, making money, living nicely, it's well worth it to try to do what you can to do so.
We've been talking with Ron Rychlak, professor of law at the University of Mississippi School of Law, and our resident sports law expert. And before we conclude, I'd just like to ask you one question that I always like to end these with. What do you recommend for members of the audience who want to learn more about this to read? Articles, books, something that they can kind of take away from this conversation and get a deeper dive.
Well, one of my favorite listservs, or I don't know what you call them nowadays, but I get a daily blast called Extra Points, which there's a free tier, and you can just get the free tier and get an awful lot from it. That keeps me up on a day-to-day basis. My colleague Will Berry has written a book. It's College Sports Law in a Nutshell by West Publishing. It's about to come out in a new edition, so you might want to hang on for the new edition. But that's kind of a background across the way. But there's so much stuff online. Oh, and I want to point out, I remember Justice Kavanaugh in the Alston case, who wrote the long dissenting opinion or separate
Okay.
opinion,
Okay.
who really encouraged what happened in House.
Well, great. I think what I'll do is I'll find an excerpt from that and share that with my class. And also I'll post in the show notes. You've written extensively about this, and I'm going to share some of that with our listeners. So once again, thank you for your time, Ron Rychlak. Really appreciate it. And we'll have to have you on again in the future, because we just know that a year or 2 or 3 years from now, the law will have changed again, I'm sure.
Maybe in 2 weeks.